Good morning, everyone.
Good morning, Your Honor.
Morning. We're just waiting for Darius to call us. All right, good morning. We're here on Speed Drive versus Anchor. Just please be aware that these proceedings are being broadcast and will be archived on YouTube. And each party has 20 minutes. If the appellant would like to reserve some time for rebuttal, let us know. I think the clock is set at 5 minutes. It'll flash yellow at 5 minutes, but if you want something other than that, let me know and I'll try to alert you.
5 minutes will be fine, Your Honor. I'm sorry.
Okay, with that, we'll go ahead and get started.
Good morning. May it please the court. This is an appeal from a motion for summary judgment that was granted in Seminole County, Florida. My client, Speed Drive Incorporated, took an assignment of benefits from the Parkers in regards to repair of their home in regards to actually two separate losses. The defendant has filed a motion under a decision out of the 3rd District, Cahuarga. The Cahuarga court ruled that under Article 10, Section 4 of the Florida Constitution, that the property was protected from such assignments by the being homestead property.
Well, let me this counsel. The Cahuarga case, if that's, I don't know how you pronounce it, but we'll go with that. That dealt with subsection 4A, which is the involuntary sale, or which is the lien provision. And counsel in this case for Anchor is relying on 4C. So my question is, what relevance does that have to this particular case?
Well, 4C has no relevance to this case, Your Honor.
Well, that's they're riding 4C. That's if I understand their argument correctly, they're riding the 4C horse.
They're trying to ride the 4C because 4A would knock them out of the water. 4A is the correct one that would give the exemption from the homestead exemption. It states that there should be exempt from forced sale under process of any court, no judgment, decree, or execution, except for payment of taxes, assessments, obligations contracted for the purchase, improvement, or repair thereof, or obligations contracted for house, field, or other labor performed on the realty.
Was it conceded that this property is in fact homestead? I mean, I couldn't see anywhere in the record where that was established, but do you concede that it's homestead property?
It would be homestead property, yes, Your Honor. And
is it, I mean, again, the record isn't clear, or at least if it was, I couldn't find it. Is Mr. Parker, is he married, or is that in the record anywhere? If it's not in the record, don't tell him.
I do not think it's in the record, Your Honor.
And
give me 1 second.
The reason I asked that, and I'll throw this out there so Mr. Shelton can respond, is even under 4C, if he's a single person, if he's a single person with no minor children, he can convey the heck out of his property. So even if 4C is applicable, I'm just curious as to whether he's married and has minor children, because that would be when 4C would come into play.
You know, I do not believe he is married. I don't know about children. I think the policy was just written in his name, which would indicate that he was single or the sole owner of the property, and that is in the record. However, getting back to what we were talking about, and realistically, defense is trying to run on 4C, but this is really 4A in what we're dealing with here today. And the cases that are supported, that they use to support their claim that this somehow is tied in, is the Cahuarga case, which deals with an attorney fee lien. Has nothing to do with repair of the property, has nothing to do with improvements on the property, as we're dealing with in the situation here with Speed Drive fixing the Parker's house. And
how did you raise the issue of 4A below, other than in your motion for rehearing?
I just did it in motion for rehearing, yes, Your Honor.
I mean, because I read your original response and I read the transcript of the hearing, and it was basically, well, Judge, we do this stuff all the time. I mean, that was your argument.
Well, Your Honor, 4C is inapplicable either way, and it shouldn't have been granted whether or not it's 4A or not, but 4C is inapplicable to the situation, as you just indicated. But in the cases that they're citing as their support for that is the Corga case, which dealt with an attorney fee lien, and the Shamus case, which dealt with a child support lien. None of these cases have anything to do with the factual situation that we are dealing with here today. They both deal with totally inappropriate situations in regards to that. And no court has ever found, besides Corga, that there is any correlation between the two. The only two cases that they do cite also is supposedly falling on this is the JD Restoration case, which is a PCA with absolutely no facts and supporting in regards to why they based it on Corga, and the One Call case, which was a PCA with absolutely no reference to anything on which to support it. So this case is one that realistically the Florida Supreme Court, has not ruled on it. No court has ruled that no district court has ruled in regards to repair that it is not something that can be done. Mechanically, if my clients were going to do some repairs on the property, they could file a mechanics lien and foreclose on the property. Same thing in this situation. So there's obviously not anything here that would prevent an assignment of benefits from dealing with the insurance benefits on the house. None of the cases, as I said, support any of this. Your Honor, this is something new that the court in Seminole County found. There is nothing to support this. We went through in my case and in our thing and just showed why. Nothing in 4C says that they cannot do that. There's nothing in the record that says that this is in any way prevented by this. 4C doesn't even prevent an assignment of benefits, Your Honor. There are numerous situations in regards to this. While it's not cited, the federal court in January said, Judge Antune said that no Florida court had ever did not invalidate an assignment based on Corga. And that was Judge Antune back in January when they tried to raise it in one of the cases there. So this is something that is just absolutely not in any way supported by either the Constitution or any of the case law in Florida. This is an incredible stretch of some case law that is totally inapplicable. I do agree that, under the Florida Constitution, that the Corga case was properly taken in regards to attorney's fees. The Shamus case was properly taken in regards with child support lien. The other cases that are cited by the defense also do not support the fact that this is a situation where it should fall. And this is clearly, as I said, within Section 4A, Your Honor. And I yield the rest of my time until my rebuttal.
Okay, thank you so much.
Good morning, Your Honor. It's David Sheldon on behalf of Anchor. Can you hear me okay?
Yes.
Thank you. I think, Judge Orfinger, you hit the nail on the head, is that we've got a fundamental disagreement here between the parties as to which part of the homestead exemption is applicable to this case. And we've always argued that 4C, which is the alienation provision, applies. They've raised, like Your Honor indicated, only on motion for rehearing, that the provisions of 4C apply. And 4C, by its own terms, deals with the situation where there's a forced sale or a lien, and we don't have that situation.
Well, you're right. Your argument is that 4C applies, correct?
That's correct, because that's the only one that deals with alienation. And so the question is this a proper alienation under 4C of Article 10?
Well, let's back up just a little bit. I guess the first question I have is this an alienation at all? What does the word alienate mean?
I don't think any of the cases that we've cited have specifically addressed that, but certainly we take the view that alienation deals with some kind of transfer by looking at the term alienation in the context of mortgage, sale, or gift, which is all of the language. I think it should be read in connection with those other words as well.
Well,
And
according to Black's Law Dictionary, alienation means a conveyance or transfer of property to another. Any transfer of real estate short of a conveyance of title is not an alienation of the estate. And for that authority, they cite Appleman on insurance law. They also say to alienate is to transfer or convey property or a property right to another. Why is, I guess the problem that I'm having here is this an alienation at all? I mean, this is an assignment of a contract right. There's no question about that. And I recognize your argument that the exemption from being grabbed by creditors under 4A would apply to proceeds. But you agree that your position is that 4A doesn't apply here. So we're really talking about the restriction on alienation found in 4C. And I need you to explain to me why this is an alienation at all, given that's the definition of the word alienate.
Well, I agree with Your Honor that fundamentally the alienation requires a transfer. And I think that's exactly what they've tried to do with respect to this work authorization and assignment of benefits.
But
because
the question
what they've done,
what, a transfer of a real property right or a transfer of a contract right?
they are transferring the insurance benefits. They are certainly assigning the right to sue for those.
Is that an interest in real estate?
Well, to the extent that the case law says that the insurance proceeds on the home do become part of the homestead.
But that's under 4A.
Excuse me?
That's under 4A.
Well, but it should apply to 4A and 4C. The same concept should apply.
Let me ask you this. What restriction, let's assume it's an alienation. What restriction on alienation is there if Mr. Parker is a single man?
Well, the language of the Constitution specifically addresses that and says that it has to be alienated only in 3 ways, either a mortgage, a sale, or a gift. And there's been no allegation or argument that what they did here was a mortgage, a sale, or a gift. They certainly view it as an assignment. Under the law, assignment is something very different. The Constitution doesn't say assignment, mortgage, sale, or gift. It says those 3.
So would you concede that the focus of our concern ought to be on what the word alienate means? If this is an alienation, arguably it's a no-go. If it's not an alienation, you lose.
If the court doesn't view it as an alienation, then I would agree that we're not dealing with the limitation on the fact that the alienation has to be done by a mortgage, sale, or a gift. Our view certainly is that when you transfer those insurance proceeds, that's an alienation. And that's an exceptionally important transfer, because you're not talking about just the right to sue us, which they've done here, but any payment that we make, we have to make that payment to them, regardless of whether they do any work on the property. And that's the problem that I see for purposes of the homeowner. They are alienating, they're transferring, they are giving this big pot of potential insurance proceeds, this big pot of money to Speed Dry, and they haven't done it in the constitutional proper method by doing it as a mortgage, a sale, or a gift. So we think it definitely is an alienation. I would point out that there's been no argument from Speed Dry's counsel, either in the lower court or in the briefing in this court, that this is not an alienation. They certainly have argued that a different exception to the exemption should apply. They certainly have argued that it should travel under 4A rather than 4C. But even when discussing 4C, which is very limited, they didn't make any argument with respect to 4C during the summary judgment hearing. They didn't specifically mention 4A or 4C in their rehearing motion.
Mr. Shelton, let me interrupt you just a minute. Judge Wallace has fallen off my screen. I want to make, oh, there he is. I just wanted to make sure that we hadn't lost you.
I'm here.
I thought maybe the discussion of alienation had done you in and we needed to call 911. All right, go ahead, Mr. Shelton. I'm sorry to interrupt.
That's all right. So there's been no argument to the trial judge with respect to alienation. So to the extent that they want to adopt this argument, it's certainly not preserved with respect to an issue on appeal. There's been some discussion about the Quiroga case. I would like to point out that although Quiroga only cites 4A, it's clear to me that it also deals with 4C, because they talk about the ultimate holding is that the attorney's fee agreement in that case was against public policy because it was done in an unsecured agreement. And then they cite to the James versus DeMaio case, which definitely discussed both 4A and 4C.
But
So,
aren't those distinguishable in that they were, in those cases, they were trying to impose a lien on the homestead. That's not what we have here. I mean, it seems factually distinguishable.
Well, to the extent that we agree that 4A is not applicable like it was in those cases where they specifically were trying to impose a lien on the homestead proceeds. So it's not triggered in the same way. That's why we don't think 4A applies. We think 4C applies. But in discussing the constitutional provisions and in reaching the results in those cases, they had to go through both 4A and 4C. They had to deal with the alienation provisions. And in both cases, they found that they were against public policy.
In both those cases, the homeowner was the one who was asserting their constitutional right. Why does your client have the ability to assert a constitutional right?
Well, there are a lot of responses to that. I would point out, first of all, that our standing to assert that issue was not raised below, and it's not raised in the appellate briefs. But to address it directly, I would say that the James court specifically said that the issue that we're talking about, this alienation only through a mortgage sale or gift, is a right that inures to the entirety of the state. And they talked about it in terms of a public policy, and they said it was not a private right, so that it wasn't just something that the homeowner or the property owner can waive on his own, that there are greater interests.
The property owner might not be able to waive it as against public policy, but is it different then that a third party who's not the homeowner and who doesn't have the constitutional right would be able to use it?
I don't see any difference. I think that if the courts in James and Quiroga recognize that the homeowner couldn't waive this right, then because it's against public policy and therefore it's unenforceable, it suggests to me that it's unenforceable against any party. And I would point out that in James, they cite to a really old case, Carter's Administrators versus Carter. And in that case, the property owner had died. And so the issue was being raised, as they indicate there, by the children and the heirs. And the court ultimately agreed with the children and the heirs that the promissory note in that case because it was an unsecured agreement, was invalid and the waiver was unenforceable. I would point out, since it wasn't raised, we certainly didn't brief it, but I certainly am aware of other cases where courts have allowed third parties to assert public policy and argue that a contractual term that the plaintiff is trying to rely on is unenforceable. And so those cases that allow the defensive assertion that a contract is against public policy, we would rely upon those as well, to the extent that our standing is being challenged at this point at oral argument. But like I said, it wasn't challenged below. It certainly wasn't challenged in the briefs to this court. It was not an argument that's preserved. And so it's not an issue that we've briefed, but I think there are lots of case law that would support that.
Anything further?
I think I would end with just a comment that the Quiroga case and the James case, even though the homeowners were there and were asserting issues, the language that the court used in terms of talking about this as being against public policy and unenforceable is something that cuts across the case that we have, where you're talking about a vendor suing the insurance company. I think the same constitutional limitation should apply here as they did in that case. And certainly in those cases where they were dealing with homeowners' insurance proceeds, I think the court should follow the rationale of Quiroga, and I think the court should affirm the summary judgment. One last thing I would point out is we have a lot of litigation with respect to this issue. We've got other cases pending at the trial court level. We've got another case that's pending in front of this court. We put notice in of that. The case is set for oral argument on the 28th before a different panel of judges, same attorneys, same briefs, basically. So it's an important issue, and we'd ask that the court affirm. Thank you.
Thank you. All right, Mr. Heil. You're on mute. There you go.
Sorry, Your Honor. Once again, the cases that are cited by defense are the two cases, Quiroga and James, that cannot in any way rely on 4A. They have nothing to do with repairs. They have nothing to do with improvements. They have nothing to do with the house itself. It has to do with an attorney's fee lien and a child support lien. So any reference or any connection between that case and these is totally and completely disconnected. There just absolutely isn't. This is not Mr. Parker coming in here trying to assert anything. This is Mr. Parker, going through a speed dry to get his house fixed from a couple of claims. That's what this is all about. And there's nothing been stated by defense that in any way would tie this over to either one of those cases. The linkage just isn't there between this instant case where they were talking about repairs, improvement, repairs to the house after claims. Mr. Parker contracted with my client to get these repairs done. They're trying to get these done, and the insurance company is just doing everything in their powers to prevent that from happening. The defense said he didn't see any difference in regards to these cases. In the one case he was citing in regards to where there was, who actually could bring this and who actually could raise this. What is different, Your Honor? In this case, it is somebody on behalf of the Parkers bringing this, and Mr. Parker's not looking to get enforce any constitutional rights. In the cases cited by defense, one of them was the heirs and the children, which obviously after the death would become the owner's interest in that. But there was nothing to do with the third party ever getting into that. The Florida, I put this in my brief, that the Florida legislature recently last year took up the issue of assignments. They did not find that. They just filed in 627-7152, the new law they passed put some restrictions on assignments and the way they had to be done, but once again did not in any way find anything wrong with assignments overall. The bottom line is, Your Honor, there just isn't any basis for the extrapolation or the twisted extrapolation of Corga and Shames into this situation. My client is simply doing repairs to a house. It is within the Florida Constitution, 4A to do that, and it simply should be allowed, and the motion for summary judgment should be reversed. Thank you, Your Honor.
All right, counsel, thank you very much. That'll conclude our docket for the morning, and so we'll be in recess. Have a great day and stay healthy.
Thank you, Your Honor.